new documents that are coming out. I haven't read them. I've seen them. I've heard about them. Let's get familiar. So the first one is a motion requesting clarification of the sealed order. It says the District of Court in the Second Judicial District of the State of Idaho in and for the County of Latah. State of Idaho plaintiff versus Bryan C. Kohberger defendant. All right, this is a motion requesting clarification of sealed order for disclosure of IgG information and protection order. So this is some more IgG stuff. Like I said, man, I was listening to and hearing some stuff. I think it was on some kind of documentary or whatnot. And they were talking about how great Ann Taylor is of an attorney and how good she is. And I think, they're probably correct and they're probably right. But when it comes to this case here, if she's this amazing lawyer and all she's doing to defend this guy is try to use 1880 law to get the grand jury thrown out, which, like the prosecutor said, you just go in a big circle and you get it done anyways, and you have to go forward anyway. So it was a pointless argument. And then you look at the IgG stuff, right? Another pointless argument. It won't affect the STR. It won't affect the DNA that was collected from Bryan Kohberger's dad in the trash. Like, that IgG stuff is completely separate from those things. And the STR profile that matched Bryan Kohberger, his dad's DNA was used for that warrant or part of that warrant, has nothing to do with the IgG stuff. The IgG stuff is like a lie detector test. The IgG said that, go look at Bryan Kohberger. The way you test the accuracy of the IgG is you go and look at the suspect they pointed at and test them. If it comes back a match, that means you did the IgG correct. If it comes back not a match, that means you did something wrong. This is equivalent to somebody taking a lie detector test and failing said lie detector test because this test didn't go in Bryan Kohberger's favor. And then having your lawyer ask the court to put in that lie detector test because they want to somehow throw out the lie detector test because the person that was, running the lie detector wasn't, let's just say he wasn't qualified. How does that affect the other part of the case? The real evidence that was taken out, the real stuff that was put there, the warrants for his phone pings, the test on the DNA from the sheath to him, the taking out the DNA from his dad or the trash out of his dad's or finding DNA out of his dad's trash. Those are completely separate and completely legal. That's where where I stand on this IgG stuff. I find it frustrating. And I know that the state of Idaho hasn't had a situation like this, which is the reason why they're having to go through this entire process. And they're hoping when this is over, nobody's ever going to have to ask for this stuff again because it's not going to be relevant at the end of it. And so they have to go through this process. Unfortunately, it's the first one here. So it has to be entertained. But, the IgG and its usage and its, the hidden names or whatever you want to call it, of those that matched isn't an uncommon tool from law enforcement. It's just uncommon to Idaho. It's common in many other places. And it has precedent in those other places. So those things are going to be brought up. The judge was ready to go to court. He was ready to sign for a trial date. He's ready to go now. That kind of tells me that he's probably thinking that this argument with this IgG stuff probably isn't going to go anywhere. You're looking at, Bryan Kohberger not having an alibi, most likely, which he's already been turned down, his grand jury indictments being turned down. And based on the fact that they're ready to go to court, his argument for the IgG looks like it's probably going to be irrelevant, which it should be. What leg do they stand on? They're hoping that somebody in cross-examination says something that was different than what they wrote down or said, things like that. And like I've said multiple times, memory can be tricky, which is why you want to push out, court as long as possible, especially if you're, not innocent. I'm not going to say that he's guilty, but that's no indication that he is in fact guilty or not. Just my observation and my speculation. Let's continue this. The court's sealed order states that no individual in the family tree may be contacted by the defense and any agent of the defense without prior authorization of the court after a showing as to why such contact is necessary and material to the preparation of the defense. The defense has, as part of necessary work, has previously identified family members and work has been conducted. The defense does not expect to use the protected material to identify people to contact without further order of the court. However, the defense needs to continue its investigation with witnesses and resources generated from the source outside of the protected materials without worry. The plain language and the protective order could be interpreted to prevent that work. The defense seeks clarification or a specific language of the protective order. What they're trying to figure out and what they've said in their court hearings and their files that they were documented was, One, was there anybody that they used DNA or used their ancestry or what? I'm gonna call it ancestry. It's not ancestry. I'm just gonna call it that. Is there somebody that opted out of allowing, their DNA to be used to find somebody? The other thing that they said was that were any other of Bryan Kohberger's family members investigated who were around, the 1122 King Road residence on November 13th? That was specifically his defense when it comes to that is that basically he has a family member that could have committed this crime, even though his DNA matched 5 something octillion times, to the DNA on the sheath. And it matched also as the son of the person whose DNA was recovered out of the trash at his family's house. They still think that there's somebody out there who has his DNA that's a family member that wasn't checked. Like I said, I mean, the arguments here are so bad. I mean, you go and look at Richard Allen and you go look at the Delphi case, you can see a huge difference between the arguments. And I don't even think that Richard Allen is completely innocent in that situation. I think there might be some more, there. Let's continue this. Yeah. It's just so happened a family member who just so happens to be in the area while BK doesn't have an alibi on the night that he just so happens to have his phone off. And this person also, who's a relative of Bryan Kohberger, just so happens to be the similar build, height, and weight. Obviously the eyebrows, could be a family trait, but is the stylish Hyundai Elantra something that is passed on through the Kohberger family's, tree as something that is everybody has to have? Everybody driving a white Elantra in that family? I don't know. It's a bad argument. All of it is a bad argument. I still don't see, so many people defend this man, not to the extent where I'm saying that, they don't think he's innocent. That's one thing. But to the part where it can be anybody else, including FBI, the chief of police, neighbors, anybody else. But it's not Bryan Kohberger, not the guy whose DNA is there, not the guy who had his phone off during the time of the murders, not the guy whose car is seen on camera in the area. And they can tell that it's his car because, the missing license plate and things like that. Not him. There's no way in hell he could have done it. No way. In fact, I had somebody say that if he did do it, then we wouldn't have known because he would have been so good at it that he wouldn't have left evidence. I mean, that's almost damn near warship. I don't get it. I don't understand. It don't make sense to me. I understand being suspicious about the 8 hours that, 911 wasn't called and, the roommates calling friends and stuff like that. But to completely say that this guy is 100% innocent without looking at all the evidence and what little evidence is there that we can see makes it really difficult for it not to be him. And then when you look at his so-called defense and what they're arguing for and, the fact that he hasn't given a real alibi, I just don't see where we're looking at a guy that you can say is, this is like making a murderer part 4 or something. I don't see it. He's not from the area. That's one thing that people say is like, oh, you're not from the area. That's the reason why. Well, neither was the detective that was investigating the case. He wasn't from the area. And I think there's 30,000 people there. I think 20,000 is part of the school. So they couldn't pick anybody else. And you're going to go look at your applications for good suspects instead of your history and your log of people that have been arrested for violent crimes. You have this whole database as a police department to find a good fall guy. And instead of looking at that database, you go look at the guys that are applying to be law enforcement. I don't understand that. I don't understand how that fits any box whatsoever. I don't know. I hope somebody can make it make sense one day, but I doubt it'll ever happen. All right, let's continue this. The defense's part of necessary work has previously identified family members and work is being conducted. Defense does not expect to use this protective materials to identify people to contact without further order of the court. However, the defense needs to continue its investigation with witnesses and resources generated from sources outside of the protected materials without worry of the plain language or protective order could be interrupted to prevent that work. So they don't want to scare somebody off by saying that we use that word. They're not going to want to talk to us. It's kind of weird. You would think that, somebody who doesn't want to get involved would be reassured to be a part of the protective order. You know what I mean? Because their information is not going to come out. I don't know. Maybe I'm reading that wrong and I'm finding it confusing. The defense seeks clarification of specific language to the protective order. All right, let's continue. This says objection to defendant's motion to change venue and request for a scheduling order. Comes now the state of Idaho by through the Latah County prosecuting attorney and objects to the defendant's motion to change a venue as it is premature. The state requests that the court set a trial date, a briefing schedule for a defendant's motion, a hearing date for the motion to be heard, and a deadline supporting memorandum, affidavits, and witnesses' disclosures sufficiently in advance of hearings so that the parties can adequately prepare. defense motion of change of venue is premature without the sufficient basis. Defendant has not provided the court with adequate information to conclude that Latah County jury could not fairly and impartially decide the defendant's case. In Idaho, a motion to change of venue within the discretion of the trial court, state versus Wynn. Idaho's appellate courts look at several factors while determining whether a trial court exercise is discretion in deciding a motion to change venue, including affidavits indicating prejudice or absence of prejudice in the community, and testimony of the jurors at voir dire as whether they had formed an opinion on the defendant's guilt or innocence based upon adverse pretrial publicity. Other factors for consideration are whether the defendant's challenge for cause in any individual jurors, the nature of pretrial publicity about the case, and the duration of time between the publicity and the trial itself. The Idaho Supreme Court has also explained that publicity itself does not require a change of venue. So, and I get all this, and that's basically what they're saying, right? They're saying, no, it's premature, and you haven't given us a reason as to why. So this tells me a couple of things. This tells me that this whole pushing it to, summer of 2025, maybe even summer of 2026, is just a tactic. If they're willing to do this right now, well, it's premature instead of, pushing it back and holding off as long as possible. That tells me that that was a tactic. Now, why are they doing that? My opinion, it is for this motion of venue, to change the venue. Reason being is, well, one, the prosecution has played their hand. I've said this multiple times. They want to do this in the summer, and within that 6-week period, that there is no classes in high school and or in the university. And Taylor's brought up doing this in 12 weeks, which would completely blow their schedule for wanting to do that within that specific time, right? Now, is it fair to the victims' families? Is it fair to the defendant for this to be moved 1 year because of a conflict in logistics when it comes to the location of your courthouse and the location of the high school and the amount of people that is expected to be there? If you can't handle it, put it somewhere that they can, and don't violate these guys' rights of a, especially Bryan Kohberger, of a quick and speedy trial, and for the rights of the victims to have their justice as well. Postponing this longer and longer doesn't allow for closure. I think if they end up getting the change of venue, don't be surprised if this starts getting scheduled sooner. It's basically also the other thing I'm trying to say. Like I said, I think they're just going to try to get the venue changed. Once they get that, then we might see a court date much sooner than we think, maybe even earlier than maybe around March of 25. And so this is the state's response to defendant's motion. State's response to defendant's motion to allow certain experts and investigators protected access to view the IgG materials, and motion requesting clarification of the sealed order for disclosure of IgG information and protection order. So another IgG issue there. I'm not sure what they want based on the top. Let's read this a little bit. Come down, State of Idaho, and by and through Latah County prosecuting attorney, and respectfully submits following responses to defendant's motion to allow certain experts and investigators protected access to view the IgG materials filed on February 1st, 2024. The defendant's motion requesting clarification of the sealed order for disclosure of IgG information and protection order filed on February 8th, 2024 regarding the expansion of protection order to include Dr. Leah Larkin, Becca Barlow, and Stephen Mercer. The state does not object. Regarding the expansion of the protection order to include unnamed criminal investigators, unfettered access to the IgG materials, the state objects. So they haven't even named who these people are. Yeah, I'd object too. I wouldn't want to just give out that information to just anyone. At minimum, individuals who have access to any IgG materials should be named. Further, the defense has failed to make adequate showing as to why such individuals need the information for preparation of the defense. The defendant states that the information is requested to investigate how and when Mr. Kohberger was identified as a suspect. This information can be obtained by the Toohey letter from the FBI in the state dated November 28, 2023. The state objects to the balance of the IgG materials being provided by the criminal investigators and the reasons articulated by the court in its protective order. The FBI can only do the IgG stuff if there's no suspects. I mean, think of the Golden State Killer or, some of these other guys where it's a cold case and they have no idea who the killer is, and they have this DNA, and the person who's committed this crime has never been in the system, never been in CODIS, so there's no idea of who they are. And now they have this technology to try to find family members and narrow it down. All these guys that have been caught that way, there's never been an issue as far as when or why or how. Everybody knows it's because of the DNA. Why is that a problem in this case? I don't understand why she's going to go into it and say, hey, this is, they use this tool that's been used multiple times. It helps solve Golden State Killer, serial killer cases. They use this against my client, and we think it was wrong. And we have We have all these experts that can say that using this is wrong. And then the state is going to come back and say, then don't use that. We took DNA, we took trash out of a trash bin at Bryan Kohberger's parents' house, which was 100% legal. You can't do anything about that. And we tested it towards the DNA on the sheath, and it came back as the father of the person who left the DNA there. There ain't nothing you can do about that. I don't understand why this is such a she's making such a thing. But then again, it's probably because there's nothing else to argue. You know what I mean? So if this is the only argument, it's probably not a good sign for Mr. Kohberger. Regarding the defense's motion requesting clarification of the sealed order for disclosure of the IgG information and protection order, defense experts or investigators should not be allowed to use protected materials to identify individuals or witnesses to contact without prior authorization from the court, and after showing why such contact is necessary for the preparation of the defense. This would not prohibit the defense from contacting potential witnesses learned through the sources outside of the protection information. The state respectfully submits that appropriate course of action would need to be for the court to amend sealed order and disclosure of IgG information and protection order to allow Dr. Leah Larkin, Bika Barlow, and Stephen Mercer access to the IgG materials disclosed in the defense. The criminal investigators seeking access to the information should be named in the order, and those investigators should only be allowed access to November 28, 2023 letter provided by the defense that the state also requests the following language for an amended protective order. The court orders that the defense counsel Ann Taylor, J. Longden, and Alyssa Massoff, defendant Bryan Kohberger, and Dr. Leah Larkin, Bika Barlow, and Stephen Mercer may view the materials provided, may view the November 28, 2023 letter contained within the materials, and any further dissemination of the materials or the information contained within the materials must first be approved by the court after the adequate showing by the defense as to why such information is necessary and the material to the preparation of the defense. Additionally, no individual learned solely through the review of the materials shall be contacted by the defense or any agent of the defense without prior authorization from the court after the adequate showing as to why such contact is necessary for material and preparation of the defense. So yeah, they're basically saying they want extra people to see this. We don't know who these people are, and they haven't even given us an answer as to why they need it. It's just a lot of cloud, in my opinion. Let me see. Would a change of venue actually help BK? Does anyone in Idaho not know about this already? You'll be surprised. There are some folks who don't watch TV or have the internet, probably some elderly or older folks. There's also a lot of individuals who are out there, maybe perhaps, and like I said, just don't follow the news at all and aren't on YouTube or TikTok. I can see there can be finding some people in Idaho that can come together. They can find 12 that aren't familiar. And even if they are familiar, that doesn't necessarily mean that they aren't fit for jury. You'd have to be able to come by and say that you can make a unbiased judgment based on anything you have heard. I mean, when it comes to high profile crimes, people are going to hear about them.